Selamat pagi. Maaf, saya belajar bahasa Indonesia. Jadi uh, ha- hari ini saya bahasa di Inggris. Yeah, kasih. Okay, so I think your lecturer has given a summary, spoken a bit about legal pluralism at the start. I've written some notes as well. I'll just I'll go through that just quickly about introduction to legal pluralism. Is that okay? I'll sit. Okay. So I'm going to talk about land rights and legal pluralism in the Australian context. But I don't know much about Indonesia. I went to a conference at UI in January this year, which was about legal pluralism. So I learned a little bit about Indonesia, adat law, and some current issues, but I'd love to learn from more and have a discussion with the class. So to start with, I think Indonesia really seems like a very interesting place to learn about legal pluralism, especially because there's so many islands and cultures, religions, languages. And I think your lecturer is saying you've already learned a little bit about legal pluralism in the start of your course. I think in Australia, it's a very positivist system, and we don't have as much pluralism that we really talk about actively. So it's really interesting for me to hear that you in Indonesia, you learn about legal pluralism really even in your undergraduate degrees. I see. So when we're talking about legal pluralism, we start with the concept that law has no fixed definition. And as your lecturer is saying, it's the coexistence of legal orders, the state, custom, religion, transnational law and global law, and regulatory pluralism. So really it's about living law, the question of how do people use law in practice from day to day. And it might be any combination of different types of laws. In recent years, like in terms of the history of legal pluralism scholarship, early on, there was a focus in legal pluralism on disputes about when there was a conflict happening. And later people started thinking, well, maybe we shouldn't just look at conflict. We should also look at day to day, like how do people have property administration and governance? And so since the 1970s, that's when legal pluralism scholarship was started in the academic world. I think with a lot of the academic focus comes from questions of modernity, when in the context of the 19th century rise of the nation state in Europe, industrialization and colonialism, and things moving more and more towards a focus on fixed property rights for all around the world. Until industrialization, there was a lot more flexibility and lack of formal ownership. The communities between each other decided who owned the land. It didn't have to be written down and registered with the government necessarily. But things really started to change in the 19th century. So in terms of, I'll keep going. So there's questions and debates that come with legal pluralism. Firstly, is legal pluralism needed in order to expand on positivism and construct good law. For example, some constitutions build on history of the country when they're drafting the constitution, and that's a form of pluralism. And that certainly doesn't exist in all countries. Like, it's really interesting because the Australian constitution is very like basic, and it doesn't really speak about a lot of rights and things that a lot of constitutions, like Indonesia's constitution, there's a lot more, I think, context and history written into it. And then also there's a debate about what is pure law. And there's kind of things like I was saying, when the history of legal pluralism coming from, there was a anthropological interest in societies and people trying to find like what is the essential universal law before the modern world. And so even then it's a debate about, why are people so worried about creating a hierarchy of laws?
Pada intinya itu bahwa kalau dilihat pada bagaimana berkembang dari zaman ke zaman, hukum itu berkembang dari zaman ke zaman, dan hukum itu berkembang berbeda-beda tergantung dari kondisi tiap-tiap masyarakat. Makanya hukum di masyarakat di Indonesia dan Australia pasti beda. Sementara masyarakat Indonesia dengan di Jerman pasti beda. Juga bahkan di kita sendiri hukum masyarakat Bugis, Jawa, Sunda pasti beda kan? Nah, jadi di sini bagaimana pluralisme bagaimana perbedaan timbul dari tiap-tiap masyarakat berdasarkan sejarah dan perkembangannya. Dan itu kan dilihat bahwa dengan tren hukum modern, terutama dari abad 19 atas timbul konflik hukum, persoalannya menjadi pertanyaan bahwa apakah pluralisme hukum ini sesuatu yang diperlukan, contoh yang masih relevan dalam konteks saat ini di mana sudah ada hukum modern. Nah, jadi di sinilah kayak dari di Australia itu mulai dari tahun 60-an mulai terjadi perkembangan dari studi dari pluralisme ini untuk mempelajari bagaimana pluralisme hukum ini berkembang dan bagaimana dia dikontekstualisasikan dalam konteks masa sekarang dalam berkaitan dengan misalnya dari bidang-bidang hukum yang berbeda atau dari sumber-sumber hukum yang berbeda di antara tiap masyarakat.
I see. But even though there's these debates about where some people, like there's debate about the degree to which legal pluralism is relevant, and that's since the 1970s to now, in the rise of international law and transnational law has made even people who are very positivist lens on law agree that there are some plural legal orders. But regardless, legal pluralism can only exist as far as the laws are recognized by other state, is a way that a lot of people, lawyers particularly in positive focused jurisdictions, look at things. There's the concept of semi-autonomous social fields. It was developed by a well-known legal scholar called Sally Folkmore, and that was in the 1970s, popularizing a sociological conception of law as being interlinked with a social context, and looking at how law operates in social fields in a piecemeal sort of way, where formal state law is only one factor that shapes many, many people's lives. But at the same time, building on that, there's discussions that this is just kind of a gap approach, and you can't see the state law as the main law and only other legal orders filling in between that primary law. That's too simplistic of an analysis. But basically, when you're analyzing what kinds of laws people use in their social and economic life, it does require social science theoretical explanation. And legal pluralism in the context of industrialized societies, multinational enterprises, migration and cultural diversity, there's so much to consider, and particularly in a country where that's really part of your constitution and accepted. So it's really interesting here.
pemikiran dalam hukum, termasuk misalnya sosiologi hukum yang meninjau tentang bagaimana hukum itu dikontekstualisasikan dengan kondisi masyarakat yang ada. Di sini nanti kita berapa? Ini enggak ya? Nanti kira-kira mungkin tahun depan ini kalian akan ada yang belajar kayak sosiologi hukum, filsafat hukum, politik hukum, dan itu yang nanti kalian juga akan pelajari bagaimana hukum itu dikontekstualisasikan dalam kondisi masyarakat dari masing-masing. Nah, di sini lo timbul juga bagaimana pemikiran, bagaimana kontekstualisasikan hukum, pluralisme hukum ini, keberadaan hukum yang berbagai beragam hukum yang berbeda ini, bagaimana mengkontekstualisasikannya dalam kondisi modern, dan terutama dengan banyaknya perkembangan dari berbagai entitas hukum yang ada, seperti misalnya dalam konteks international corporation, internasional, atau misalnya dalam konteks misalnya dalam konteks kerja misalnya hukum laut lah, dalam konteks laut di mana ada misalnya mungkin pertanyaan baik ini kan dari status hukum dari tiap-tiap wilayah laut berdasarkan kondisi dari nasional atau hukum barat, hukum ada. Nah, jadi itulah mengapa kayak ada timbul bagaimana tim peran hukum ini.
Thank you. So now I've finished introduction to legal pluralism. I'll talk a bit about the history of land rights in Australia. I wanted to talk about legal pluralism first because I think it's really important for understanding land rights in Australia. But it's interesting because it's actually, like I was saying, not something that people really discuss much actively.
Karena ini pertama konteksnya juga penting dalam pembahasan selanjutnya, dan itu adalah masalah pluralisme hukum ini kayak sesuatu yang mungkin orang jarang bahas karena mereka pikir mungkin ini terlalu rumit atau mungkin kurang relevan, tapi ini juga ada penting sekali dalam memahami konteks tanah baik di Indonesia maupun di Australia.
Thank you. And I just want to say, I'll talk about some concepts from Indigenous law in Australia today. I'm not Indigenous myself. Only 4% of the population of Australia are Indigenous people. So it's, not my culture, and I'm not an expert to talk about it. And if after class anyone's interested in reading things from Indigenous legal scholars, I can definitely pass that on to you.
Tapi beliau sendiri bukan bagian dari masyarakat adat di sana, jadi mungkin beliau kayak kan yang kita membicarakan secara lebih betul esensinya dalamnya, karena beliau juga tidak suci bagian dari masyarakat adat, bukan sama kayak kita bilang mungkin kayak orang yang bukan Makassar mungkin akan sulit membahas lain bagaimana kebudayaan dan ini kata itu. Nah, tapi beliau akan senang meneruskan apabila misalnya kalian punya pertanyaan-pertanyaan yang berkaitan dengan bagaimana aturan hukum adat di Australia.
And that I did want to say, I think it's interesting, maybe for those of you whose families are from Makassar and around this area, your ancestors actually might have had some contact with Indigenous Australians a lot earlier than my family did. And because I'm sure you already know about it, like the trade that happened in the past with Makassar people and Yolngu tribes and other tribes in North Australia. And actually, when I was working in North Australia, a lot of Indigenous people actually spoke to me about their ancestors having contact with people from Makassar. And they pointed out trees from tamarind trees from the seeds brought from Sulawesi people. And they had stories still from their grandparents, whose grandparents used to trade.
Sejarahnya orang Makassar itu sudah lama berdagang Australia atau Australia Utara. Ada sejarahnya dulu yang jadi ketemu dengan warga masyarakat adat di Australia Utara, yang dimana banyak masyarakat Australia Utara itu menceritakan bagaimana mereka dulu berdagang dengan orang Australia, bagaimana banyak pohon tamarin di sana itu yang buah yang bibitnya berasal dari Sulawesi Selatan, dari Makassar, dan ya bagaimana masyarakat Makassar itu punya pengaruh besar dalam adat istiadat dan termasuk sistem adat di masyarakat adat di Australia. Mungkin salah satu contohnya yang paling populer itu adalah artinya itu sambal belacan. Tahu kan sambal belacan yang sambal kayak sambal rawa begitu? Nah, yang biasanya kalau makan di bawah. Nah, itu juga ada di Australia Utara karena dibawa dari pedagang Makassar di sana.
So, in terms of land rights all over Australia, Indigenous people there have been on the land for at least 60,000 years. And through that time, they had legal systems governing their societies that varied according to the area and the tribe. But there's an overarching belief that people in the land are connected because the land was created by ancestor spirits in a time before humans called the dream time. And these spirits then became the land. And because people also came from the ancestor spirits, they have a duty to protect the land. Because there's thousands of tribes across Australia, the land ownership systems vary. But where I worked in North Australia, people are connected through the land through their mother and their father as part of the kinship system.
Dan tiap-tiap masyarakat adat itu punya pengetahuan sendiri padatnya tentang tanah. Tapi secara hakikatnya masyarakat adat di sana itu percaya bahwa mereka punya ikatan khusus dengan tanah karena menurut mereka tanah itu diciptakan oleh arwah dari leluhur mereka, arwah dari mereka di dahulu di zaman penciptaan mereka yang menjadi bermanifestasi menjadi tanah itu. Dan karena itu tanah adalah macam terdapat ikatan spiritual antara masyarakat adat dengan tanah tempat mereka tinggal.
And these kinship systems are very complicated systems. One of the purposes, of course, was because in small communities, they want to stop people from having children with people they're too closely related to. And it reminds me about a story that an Indigenous person told me once about how the British royal family ended up getting a lot of illnesses because they were marrying their cousins, and because they're afraid of marrying someone who wasn't in the royal family. And this Indigenous man was laughing because the British came to Australia and called the Indigenous people primitives, but really the Indigenous people had a much more advanced understanding of genetics. They were a lot smarter than the British in that way.
Jadi problematik juga problematikanya adalah karena kecenderungannya itu di Australia ada kecenderungan itu di antara masyarakat itu yang kawin hanya dengan sesama sukunya sendiri, sehingga ini kayak kan kalau misalnya karena mengakibatkan terlalu eratnya hubungan genetik antara setiap suku itu, dan ini bahaya kan punya potensi berbahaya bagi keturunannya, dan dia berbanding menceritakan juga tentang bagaimana kita dari zaman dahulu dari ada orang pribumi di Australia cerita dengan dia bagaimana tradisi ini agak sama dengan yang dilakukan oleh keluarga kerajaan Inggris yang keluarga kerajaan Inggris yang dulu biasanya kawin sama sepupu sendiri kan untuk menjaga kesatuan darah. Jadi ini yang kayak sesuatu yang agak serupa dengan apa yang terjadi di masyarakat yang ada di Australia yang banyak yang kawin dengan sama sukunya sendiri sehingga akhirnya yang sesama sukunya itu ya intinya suku semua harus saling kawin ya akhirnya jadi kayak incest begitu.
So about this kinship system, because you're marrying people from different areas, it means like your mother's country will be in one place, one tribe, and your father's country will be in another area. And because of that, people have different responsibilities to different places. The father's country, they were the primary custodian, and the mother's country, they were like the monitors to be checking that the primary custodians were doing their job right. That's a very basic summary, but it's a lot more complicated than that.
Jadi pada ibaratnya itu ketika misalnya ada orang yang kawin di luar ya, maka dia akan punya tanggung jawab yang berbeda pada tiap-tiap tanah dari sukunya. Misalnya suku orang ini kawin sama orang dari suku A, kawin sama orang dari suku B. Ketika dia mengawin lalu memiliki anak, maka anaknya itu akan punya tanggung jawab tertentu ke masyarakat suku dari bapaknya dan ibunya, termasuk dalam urusan tanah ini. Dan itu akan bergantung dari titik tiap suku sendiri, termasuk soal waris. Kira-kira misalnya mana yang misalnya warisnya tanggung jawab tanah, hubungan tanahnya itu diturunkan dari garisnya bapak, sementara dengan yang diturunkan dari garisnya ibu. Apa seperti di kasusnya di Indonesia ini kan kayak orang Makassar dari nasabnya kemudian waris sama keluarga kan dari bapak kan, keluarga turunan bapak. Sementara di Minang dari turunan ibu. Ya, itu.
So this was the system of land governance that was in place for a very, very long time in Australia until the arrival of the British in 1770. But when the British arrived, they wanted all the land for themselves to exploit it for its natural resources, similar to colonial projects all over the world. But when they arrived and there were people on the land, the British had a problem. They wanted to take the land. If there were people there, what were they going to do? And that's what they were thinking. So in the 18th century, Europeans could legally gain sovereignty over a country in three ways. The first was by conquest, by way of force, like military force, by cession, but sovereignty by means of treaty, where the previous government gives power to a new government, or by occupation, sovereignty by acquiring land currently ruled by no government or sovereign power, i.e. terra nullius, which means land belonging to no one.
Di mana tanah itu dia jadi miliknya melalui tiga cara. Pertama, melalui penaklukan. Yang kini tentaranya Trump pasti, lalu kemudian dia rebut tanahnya itu. Yang kedua, cession, yaitu dia bikin perjanjian sama suku asli. Dia tetapkan bahwa ini dengan kamu tantangan perjanjian ini, maka tanah ini menjadi milik kami. Dan yang ketiga, occupation, yaitu di mana tanah-tanah yang kosong dan tidak terurus tapi aslinya merupakan tanah adat, itu kemudian ditinggali oleh orang-orang Inggris, pendatang-pendatang dari Inggris yang kemudian dia kayak mengklaim tanah itu sebagai miliknya meskipun itu milik tanah adat. Ya, jadi kayak bayangkanlah yang Israel lakukan di Palestina. Itulah.
And so in Australia, the British decided that they could take the land under the last category by occupation because they said that it was terra nullius. And looking back now, people say to try to understand how could the British have said that land belonged to no one when there was obviously people on the land. People sometimes they've interpreted it by saying that there were some things that because their societies were so different, the British didn't recognize that there was a society. Firstly, because the agricultural practices were so different. In Britain, there was agrarian farming, agriculture, but indigenous people were nomadic and hunters and gatherers. Like they had very sophisticated systems, but they weren't recognized. That's the same with their legal system. The British didn't understand that the indigenous people also had a legal system, but because they didn't have a court building, it was all done through oral tradition. They didn't realize it. And then the third part was because there weren't buildings and everything built up cities, they thought, oh, there's no one here. So this was the basis, and just like that's a kind of a generous explanation that you could otherwise just say they made up a story because they wanted the land and they had racist beliefs. Yeah.
Yeah. Datang dan pakai tanah itu ketika mereka melihat masyarakat adatnya, mereka lihat bahwa masyarakat adat itu beda-beda sistem hukumnya di tiap-tiap hukum. Lalu dia melihat bahwa di sini tidak ada sistem hukum yang seperti kami punya di Inggris, tidak ada pengadilan, tidak ada kitab undang-undang, maka mereka menganggap kami tidak akui ini sebagai sistem legal hukum. Jadi pada saat itulah sistem hukum yang diakui Kristen cuma sistem hukumnya saja berdasarkan Barat.
So once the British arrived in Australia, they brought the British legal system with a very different system of land rights and property rights. Indigenous people suffered a lot under British colonization. There was genocide committed against the Indigenous people in a period of massacres, as well as bringing diseases like smallpox, which a lot of people died from because they had no pre-established immunity. And then many of the survivors in following generations were moved away from their lands and put on missions and reserves. And in the 20th century, there was official government policy that said Aboriginal children should be removed from their families to grow up in the white society.
Lalu kemudian orang-orang di Australia itu mengalami genosida, diserang, dibunuh, disingkirkan dari tanahnya, diusir dari rambut dari tanahnya dan dipaksa tinggal di macam kampung preservasi begitu, tempat tertentu di mana mereka harus tinggal. Lalu kemudian pada abad 20 juga banyak terjadi kasus di mana anak-anak dari orang pribumi itu diserabut dari keluarganya untuk dipaksa masuk sekolah-sekolah asrama dan di sana dipaksa untuk belajar dan dibesarkan sama orang kulit putih. Itu yang dinamakan sebagai stolen generation di Australia.
Yeah. And so because of this, many people grew up away from their traditional land and culture, but at the same time, living in white Australian society, they weren't even recognized as citizens of the country under the Constitution. Things started to change in the 20th century because there was activism by the Indigenous Australians and their supporters. And there was a big step in 1967 when there was a constitutional referendum where the majority of the country voted to include Indigenous Australians in our constitution. Mm-hmm.
Kemudian terjadi perubahan daripada masyarakat Australia, mana mulai rasa dari masyarakat adat yang terakhir bangkit, maka mulai timbullah konflik terhadap mayoritas masyarakat di konstitusi Australia.
And there was also a lot of activism about land rights at the time because Indigenous people still felt that it was their land. They'd never given the British any permission to be there. Like I was saying, because the British said it was terra nullius, they didn't think that they had to make a treaty. So, but Indigenous people felt like we never made a treaty, so you still have no permission to be here. I think.
Meskipun sudah ada Australia, tapi bahwa tidak ada perjanjian secara resmi antara dengan orang kulit Australia bahwa mereka statusnya ada di Australia. Jadi mereka dianggap ini orang materi Australia masih menganggap orang kulit di Australia ini kayak datang haram begitu. Kayak sama seperti kayak bagaimana orang Palestina menganggap orang Israel berada di Palestina kan dianggap sebagai datang haram.
And so in terms of the case law that came from this land rights activism, the first really important case was called the Nabalco mine case. It was right up in the top of North Australia, that same area where the Macassans used to come down to trade, actually. And it was the people there were suing a mining company and the Commonwealth government to stop mining bauxite on their traditional land. And the case, this was in 1971, Justice Blackburn found that the Yolngu people couldn't prevent mining on their land, but he spoke about native title as being part of, native title was existing as a common law concept, but he found that it wasn't part of Australian law, and that even if it did exist, the rights had been extinguished.
dia menyatakan bahwa ada hak adat, ya, ada hak adat itu, tapi hak adat itu oleh Australia, hakim Mahkamah Konstitusi dianggap sudah tidak ada lagi, sudah binatang, sehingga masyarakat adat sudah tidak lagi punya hak untuk melarang-larang kegiatan penambangan di sana karena dianggap tanah itu bukan lagi tanah adat tapi tanah negara.
But there were some positive things, even though they lost the case in the like the obiter, I guess. Blackburn examined comparative Commonwealth, Canadian, New Zealand, and American jurisprudence, and he accepted that the applicants had established that under traditional law, any part of the land could be attributed to a particular clan, even if this didn't mean they had a proprietary interest. And he looked at whether there was a land holding model. So he was acknowledging for the first time in an Australian higher court that there was an Aboriginal law system that existed. And he also recognized the validity of using oral evidence to establish property rights as opposed to written submissions, which is normally inadmissible in our system. But this became really important later on, being able to provide oral evidence in these court claims.
Dia menerima bahwa memang ada tim hak atas tanah dari masyarakat adat, dan yang kedua adalah dia menerima oral evidence atau bukti oral yang berarti tidak perlu pakai surat-surat, cukup melalui testimoni kesaksian oral saja bahwa kepemilikan hak atas masyarakat adat ini. Nah, dan ini yang akan jadi penting dari selanjutnya.
So that was in 1971, and then the next big development was only a few years later, 1976, when the Aboriginal Land Rights Northern Territory Act was passed by the federal government. It only applied in the Northern Territory, which is one state in Australia, like a province equivalent, where about 1/3 of the population is still Indigenous people, so a lot higher than the rest of the country. And this is a huge breakthrough because it was one of the strongest land rights protection in the whole world for Indigenous people. It gave people inalienable freehold title. So it meant that, the land was held in a trust forever. It couldn't be sold, traded, or mortgaged. And so the people had long-term security over their land. It also gave people control over their resources. They could have the right to stop mining. I'll talk about that more a bit later. And when they created this act, they created land councils. And this was like a centralized body which managed the trusts, that were established. So to help with the administration of these trusts, which were made up of all the different traditional owners. It's actually quite a complicated corporate structure that these land councils administer, which is an issue even today.
Dia pada tahun 70-an itu dia membuat suatu perda yang mengakui untuk pertama kalinya hak masyarakat adat atas tanah itu, masuk hak untuk misalnya pengelola tanah, menikmati atas tanah, juga melarang kegiatan penambangan di sana, dan juga bentuk suatu lembaga namanya land council, dewan tanah yang memiliki kewenangan untuk memetakan dan menetapkan tanah-tanah yang menjadi wilayah milik masyarakat adat. Walaupun dalam perkembangannya masih terdapat konflik dan bagaimana penetapan status tanah adat ini.
And so this was a really huge breakthrough, but it was only applying in the Northern Territory, like one part of Australia. For the rest of the country, the next big breakthrough came in 1993 when Native Title Act was passed. This was because of a court case where that terra nullius that I was speaking about earlier, someone from Torres Strait Islands, which is right in the north of Australia, went to court to try and prove his land rights for his tribe. And in going to that case, they had to go all the way from the lower courts right to the highest court of Australia. It's called the High Court. And that's where they found that there was no terra nullius and there was a society here before. So that was a huge moment in Australian legal history.
Bahwa di Australia itu tanahnya sebelum orang British datang itu sifatnya tidak view atau tidak ada yang punya. Jadi diakui bahwa orang British datang itu tidak ada masyarakat adat dan adatnya yang berlaku di sana. Dan itu jadi suatu terobosan besar dalam sistem hukum di Australia karena dia sudah mengakui lagi bahwa di samping nasional Australia Barat di Australia itu juga ada juga internasional.
And so this was a really good thing, but there were there's some disadvantages to native title compared to the land rights scheme I talked about before, which is, unlike under the Land Rights Act, people were given title to their land. Under native title, they just had their rights recognized. So they didn't own the land under the legal Australian property law system, but they had the right to access the land. And if there was going to be anything happening on the land, they have the right to be part of the negotiations.
Di Australia pemilikan tetap harus tunduk pada hukum barat, tapi berkaitan dengan pemanfaatan dan terkait tanah, misalnya berkaitan dengan ada proyek apa dibikin di tanah itu, misalnya berkaitan dengan misalnya air atau hasil dan sebagainya, itu masyarakat adat di Australia itu sudah diakui haknya oleh pemerintah Australia di sana harus diterlibatkan dalam pemanfaatan dan pemanfaatan hasil.
And so there is still actually some progress that's being made to try and work in the legal system, in the courts, to try and make the Native Title Act work better for Indigenous people. And actually this year there was a ruling in the High Court that the native title rights could actually be basically it was a finding that they could equal rights that were equal to proprietary rights. And so therefore, things that had happened in the past, people could apply for compensation if native title was recognized. That's still going through the court, but it could have a really big impact on land rights because people could now sue for compensation for mining that's happened on anything else. Yeah.
Kalau misalnya ini kasusnya dimenangkan, maka ada potensi bahwa masyarakat adat yang selama ini diberikan karena kegiatan-kegiatan perampasan tanah dan aktif perampasan tanah seperti buat kegiatan pertanian, penambangan dan lain balakan dan lain-lain itu yang sebelumnya tidak minta persetujuan dari masyarakat adat karena tidak diakui hak atas tanahnya, maka kalau keputusan ini ini diterima, maka bisa dihukum, bisa diminta ganti rugi atas dasar pelanggaran signifikan di belakang hak ini.
So that's a brief history of land rights legal history in Australia. I just wanted to finish by talking a little bit about my experiences working as a lawyer in the land rights field. And then I'll tie it back to legal pluralism. So my job for 2 years was working at the Northern Land Council, one of those legislations at statutory agency created by the Land Rights Act. I was working mainly in the land rights, the legislation where people hold the title to their land. And my job was to work with the traditional owners. You can explain what traditional owners in the context. When they were helping them still claiming the land, most of the land that has been claimed, but there's still some claims. And also, anytime any businesses wanted to use the land, facilitating the process where that happens. Because basically, if anyone like a mining company or a housing, the government wants to do any activity on the land, they have to submit an application to the land council, and then the land council does due diligence and assesses it. And if it thinks it's a good application, it brings it to the traditional owners. And then as the lawyer, I would work with them to negotiate an agreement. But if there was, they had, because they have the land title, they kind of have the upper hand in the negotiation. And there would be different things like housing, tourism, and the cattle industry is really big in North Australia, beef, which I think a lot of it as in a trade with Indonesia, right? Also, sometimes working with traditional owners to try and enforce their rights to get squatters off their land, because sometimes it's very remote. So people would think that they could just go and camp there or live there, but we'd work with the police to try and take them off the land if that's what the traditional owners want. When we had the meetings all over the world now, because of UN declarations, there's a big focus on free, prior, and informed consent when working with any group. Like, maybe you'll learn about it in international law. So I guess how that would work in practice is that if there was a meeting and the traditional owners felt like they weren't ready to make a decision, we'd try really hard to not make them feel like there was pressure at that time to make a decision. And if they want to have another, like, put it off and meet again, then they can do that.
Kantor di Australian Council itu kan BPN-nya di negara bagian di Australia Utara. Karena itu dia berpengalaman dulu bagaimana jadi partisipator dalam sama berkaitan dengan masalah perizinan lahan tanah, pemanfaatan tanah, karena banyak tanah-tanah adat itu yang diklaim, yang diklaim tanah adat mau diusahakan tanahnya oleh pemerintah, tidak penambangan, kegiatan pertanian, kegiatan peternakan, sama peternakan karena tanah di Australia peternakan di utara. Itu mengapa Indonesia banyak yang impor dari sapi dari Australia. Nah, biasanya banyak tanah-tanah adat itu yang bentuknya tanah-tanah rumput, macam tanah-tanah rumput yang biasanya kalian lihat kalau jalan dari, kalau berangkat dari sini ke Pare-Pare kan, atau dari sini biasanya kalau lihat tapi banyak yang barang-barang besar gitu. Nah, di Australia juga banyak begitu, hanya bedanya mereka datang kalau kita naik turun kan. Di sana itu banyak tanah-tanahnya potensial untuk jadikan tempat buat tempat makannya peternakan, tempat makannya sapi, domba, dan lain-lain. Tapi tanah itu biasanya juga di masyarakat adat, dan makanya dan untuk bisa dimanfaatkan tanah itu harus minta izin kepada masyarakat adat setempat melalui land coaster. Nah, biasanya jadi pengalamannya Ibu Niti ini adalah dia memfasilitasi bagaimana untuk kita mendapatkan kesepakatan dari antara pihak dari para pengelola tanah ini. Dan dari pengalaman beliau berdasarkan di Australia adalah masyarakat adat ini sebagai pemegang native title atau hak pula yang tanah itu, maka mereka punya hak veto untuk menyetujui atau tidak manfaatan tanah itu, manfaatan tanah itu. Dan terutama karena penting bahwa di Australia ini ada ketegasan bahwa harus ada free and informed consent, maka pemilihan itu harus penting bahwa dan diberikan dalam keadaan bebas dan masyarakat itu paham betul apa konteks intinya ketika mereka menyetujui misalnya tanah mereka itu digunakan untuk orang beternak, orang menambang minyak dan sebagainya.
So just to finish, I'll talk about some themes from that. So to go back to legal pluralism, the Land Rights Act had a very bold promise in it to recognize the land rights of Indigenous people through the Western legal system. And so there's debate about like, has it really done that well? One thing that most people agree is positive is that it does give traditional owners real control over what happens on their land. Like if a powerful mining company wants to start mining on the land, even if they have the support from the government and they've like there's a lot of interest in that happening, they if the traditional owners say no, then that's it. Like that's the end of the story. And then if they do want the mining, then because they have the land title, they have a lot of power making the deal, and they can use that to negotiate things like employment opportunities for the traditional owners, and to get rental payments. But on the other side, there's a lot of the same issues that happen all around the world where informal land ownership is formalized into a state legal system. And people have property rights, but only with a structure that's been created by the colonial government. So for this reason, people say that the Land Rights Act, even though it gives very strong title, it's really only a form of soft pluralism. There's a scholar from University of Sydney, I think your lecturer has studied too, and he's an Indigenous man who's doing a PhD at the moment. He's a barrister, and he speaks about how that's a form of soft pluralism because it hasn't, these legal frameworks haven't actually given extra powers or agency over the land. Like there's still state bodies running them. And he's saying it's quite superficial that it says you can have your land back, but we're not really going to give you real power about it. And because of this, his conclusion is that you can't escape the trap of positivism.
Jadi dia menggambarkan bagaimana apa dari bagaimana diskusinya dengan politik beliau yang ambil PhD juga dari masyarakat adat. Beliau melihat bagaimana bahwa pengakuan hak masyarakat adat di Australia ini masih sifatnya terbatas, masih sifatnya lebih formal begitu, di mana hak masyarakat adat jadi itu sudah diakui, tapi masih terbatas apa yang bisa dilakukan dengan pengakuan hak atas tanah itu. Dalam arti misalnya kayak bagaimana tadi pemanfaatan, misalnya untuk pemanfaatan tanah itu, pemanfaatan tanah tadi yang diakui sebagai hak tanah wilayah itu masih harus melalui lembaga pemerintah. Sementara masyarakat adatnya itu masih lebih terbatas untuk kekuatannya dalam misalnya memberikan atau menolak berikan hak atas pemanfaatan tanah tersebut. Nah, jadi ini problematika bahwa di Australia ini legal pluralism masih diletak hak hukum mengenai masyarakat pemilikan tanah oleh masyarakat adat, hak rakyat masih ditempatkan dalam konteks terbatas dalam positivisme yang berlaku di Australia. Dalam arti dia belum diakui sebagai satu hukum yang berdiri sendiri, tapi cuma diletakkan sebagai tambahan dalam hukum yang berlaku di Australia. Jadi ini menjadi suatu kompleksitas, suatu permasalahan tersendiri yang masih memerlukan perbaikan lebih lanjut.
Yeah, and so because of this problems that formalization creates, there's a lot of disputes that happen. Like, for example, people have disputes about who's in the traditional owner group. And because, like I was saying earlier, people were taken by the government from their land. So they've kind of lost the connection, maybe because of the actions of the government, not through their own fault. But because of that, now some people have fights about who's really can speak for the land. And then even when those issues are resolved, there's, like I was saying, there's a lot of money that can come now because of mining royalties. And so there's conflict that can come about who's entitled to the money. Issues that all over the world happen with when people have to decide about families and money and resources. And I think, yeah, because of I was saying like people now, even when we were working on land claims, sometimes they would say, we don't even want to have land rights recognized anymore. It brings too many problems for our community, which is kind of a bit shocking because land rights, you'd think they're a good thing, but now some people not only a minority, but some people like it's too much headache, people say.
Jadi pada akhirnya bahwa ketika ada keterbatasan pengakuan atas nelayan itu dalam Australia, maka timbul juga macam ketidakpuasan dari masyarakat di Australia, di Australia sendiri karena terlalu kompleks, sementara banyak perkara, terutama karena berkaitan dengan tanah ini kan tanah di mana-mana selalu pasti ada dianggap lahan basah yang diuntungkan kan, terutama berkaitan dengan pemanfaatan hasil bumi dan sebagainya. Maka banyak dari tanah karena menjadi suatu problematika yang lebih seringkali malah lebih mendatangkan mudarat daripada manfaat, maka di Australia itu banyak masyarakat pribumi yang sudah berkata ya sudah kami lebih baik stop saja mengurus pengakuan title ini karena kami melihat lebih banyak permasalahannya dan lebih banyak susahnya daripada senangnya. Nah, jadi inilah yang kayak bagaimana legal pluralism ini masih belum bekerja baik di Australia karena masih belum masih lebih menyulitkan pengakuan hukum lain di luar hukum positif.
And then, so just a final issue is that these land rights processes are nearly always conducted by non-Indigenous people in being the lawyers, and they're done by a centralized land council based in a city, like 10 hours away by car and like 1,000 kilometers away. And so some people want to have like a local corporation that can run their where they could move the power of the land title to be run by that. And they'd like maybe Indigenous lawyers to be their lawyers who have more shared understanding of their culture and their values. But this is difficult to achieve because there aren't that many trained Indigenous lawyers, and sometimes they don't want to work in the field of land rights because of all the disputes that I was explaining. So.
Dan penetapan masalah tanah di hutan ini didasarkan pada padat itu pasti kali dilakukan oleh badan-badan pemerintah yang letaknya itu dia tidak terletak langsung di lokasi masyarakat tanah adat itu. Dia misalnya kantornya di Darwin tapi daerahnya ada di kampung di desa-desa yang masuk ke dalam. Ibarat kalau kita bayangkan orang urus tanah adatnya di tanah adatnya itu letaknya di misalnya di kalau kita kasih konteks Sulawesi Selatan lokasinya di sekitar Danau Matano tapi yang urus itu pengacara sama kantor badan hukum di Makassar ya kan kalau mau pergi tuh kayak mau pergi lihat tanahnya itu harus dari Makassar naik pesawat ke Storor lalu mau pergi masuk lagi hutan-hutan berapa jam. Nah dan itu sulit juga untuk mengamati yang menyulitkan juga untuk mengamati bagaimana kondisi tanah itu bagaimana kondisi masyarakat di sana dan bagaimana sifat dari kepemilikan tanah tersebut. Jadi itulah tantangan juga dan sekarang ini kayak ada dorongan di Australia itu bagaimana supaya masalah pengurusan tanah ini, pengurusan dan penetapan native title beserta juga masalah bagaimana pengurusan pemanfaatannya ini sebaiknya diurus oleh badan-badan setempat yang ada di memang bertempat di tanah tempat yang jadi bahan persoalan bahasan hukum ini dan juga bahwa agar pengacara-pengacara dan ahli-ahli hukum yang mengurus ini sebaiknya berasal dari masyarakat adat karena sekarang ini kebanyakan kasusnya pengurusan ini masih dilakukan oleh pengacara-pengacara dan pejabat-pejabat dari orang kulit putih Australia. Jadi karena mereka dianggap tidak memahami konteks konteks dari masyarakat adatnya ini maka diharapkan bahwa masyarakatnya dari orang-orang dan masyarakat pribumi Australia ini yang bisa menangani perkara ini karena mereka lebih paham. Ya, tapi itu lagi proses ini masih berlanjut dan masih sedang diusahakan.
So, thank you. That's the end of my presentation. Thank you so much for listening.
Jadi kita sejauh ini sudah mendengarkan suatu penerangan, suatu penggambaran mengenai bagaimana pluralisme hukum itu bagaimana suatu pluralisme hukum itu menjadi sesuatu yang memang sudah dipelajari juga di masyarakat bahkan di masyarakat barat sendiri karena meskipun masyarakat barat anggapannya bahwa dia selama ini dia bekerja sebagai satu hukum saja hukum barat tapi kenyataannya tidak begitu bahwa di Australia bahkan di negara barat kayak Australia pun hukum-hukum seperti hukum adat pun masih juga diperhitungkan dalam penerapan hukumnya termasuk dalam masalah hukum tanah hukum agraria. Dan juga digambarkan bagaimana di Australia itu perkembangan hukumnya dari yang semula yang berlaku adalah hukum masyarakat adat, tapi kemudian orang kulit putih datang, Inggris datang lalu menerapkan hukumnya, menyingkirkan hukum adat itu sehingga yang diakui hanya jadi hukum positif. Tapi kemudian perkembangan berikutnya kembali mulai mengakui kembali hukum adat itu, terutama dalam posisinya berkaitan dengan masalah agraria, masalah melalui pengakuan hak masyarakat adat atas tanah. Tapi bahkan sampai sekarang pun masih terdapat komplikasi di mana pluralisme hukum ini tidak berjalan sempurna karena hukum adat itu masih telah diposisikan dalam konteks struktur hukum positif, sehingga dia masih masih terbatas dan masih terhambat dalam aspek-aspek administrasi tertentu, seperti misalnya pengurusan pengakuan hak tanah itu yang masih harus hak wilayah itu yang masih harus diakui oleh badan-badan pertanahan tertentu, yang menyebabkan masyarakat yang membatasi hak masyarakat adat untuk menentukan sendiri kepemilikan tanahnya. Dan ini masih menjadi problematika yang berlangsung di Australia ini, bagaimana pluralisme hukum antara hukum positif dan hukum adat ini, bagaimana supaya mereka betul-betul jadi hukum yang berdiri sendiri dan tidak tunduk pada satu sama lain gitu. Baiklah, kita sekarang buka ke sesi pertanyaan. Jika ada yang mungkin bertanya, ya tolong angkat tangan. 1, 2, ada lagi? 3, 4. Ya tolong perkenalkan nama dan pertanyaannya.
Okay, thank you. Good morning, Miss. So, first of all, I just wanna introduce myself. My name is Dio Danuarta. I'm a student in Faculty of Law in Hasanuddin University. So, first of all, please forgive me if my pronoun is not perfect because this is my first time speech with English. Okay. We know Australian also customary laws that live and develop within Aboriginal Australia and Torres Strait Islander community. This customary life existed long before colonization and form an important part of the cultural identity and social structure of indigenous people. However, that recognition of customary law within Australian nation legal system remain a matter of debate whether it is a fully acknowledged or merely symbolic. So I have two question, and one is first in the context of legal pluralism, to what extent is customary law recognized within Australian national legal system? And the second, does the recognition of customary law in Australia truly reflect the principle of justice for the Aboriginal people? That's it. Thank you.
Terima kasih banyak.
Answer now. For the other question.
Maybe now something.
Okay.
Thank you so much for your question. That's a really good question. So to what extent is customary law recognized? Yeah, well, I guess like I was speaking about, it is on a surface level, it's very recognized, and the process, I was going to mention that in my speech, the way that traditional ownership is researched, it's with anthropologists who go and work with the communities and from that make family trees and things like that. But even there's a debate there about who is the best person to be interpreting and bringing reports on this system. Like, is it an anthropologist who grew up a long way away, but they have done, they've studied and they have the academic background. But some people feel like now, like maybe in the past we need an anthropologist, but now we want to speak from ourselves. So even the way that the literature about people's traditional ownership is discussed, which is what feeds into law and gives people their rights, is really like doesn't really go into true customary law. And yeah, I get people feel like there's a lot of examples where they don't get real justice because they say like maybe things in the past, like for example, there's with fracking, it's like it's when you drill into the oil into the ground for gas. And that's a big industry. I was working on a case that was very controversial because people said that yes, the traditional owners had agreed, but it was a long time ago, and they think that the old people didn't really understand what they were being asked. And now, because they had that agreement, all of this really intensive work on their is happening on their land, which they're worried about how it will damage their sacred sites. And so people feel like because it's not this system which really does deep consultation with the traditional owners, that they're still getting exploited.
Sorry, Miss. Does the recognition of customary law in Australian truly reflect the principle of justice for the Aboriginal people?
Well, I guess people would, it's a really hard question because some people would say, yes, like it's definitely like, I think the fact that there's a national system and there's consistency is good for justice, because like from what I understand in Indonesia, you have it varies according to the province and even like the district for how much adapt people are recognized. But at least in Australia, there's one national system. So if one group gets a victory, then that can translate to the whole country. But yeah, I guess some people say that, you know, maybe the system was only created to benefit the mining companies and the government, and it's just kind of brought like neo-colonialism. But it's hard. Yeah, it's people probably they still get a lot of rights because of this legislation, but it's an imperfect legislation. Like, yeah.
Okay, thank you. I get it.
Thank you, Miss. Thank you for the opportunity and good morning. So my name is Zulfikar, and I will ask, even if journalist has been annulled or cancelled, should the state normatively return full ownership to indigenous people in certain territory in order to repair the damage caused by historical disposition, even though this may affect the rights of the communities there? And does native title regulate this? Okay, yes, thank you.
Just repeat the last part.
Oh,
Just the end at the
Oh.
end. Thank you.
does the native title regulate this?
Regulate.
Yes.
Yeah. Yeah, that's a good question. When the land claim process happens, any other existing interests on the land, often it's like people that had farmers or people that have cattle on the land, they also get to come to the commission and speak and explain like if the land becomes converted to this Aboriginal land title, how will that affect me? And it causes a lot of problems because of like the government might really support these people because they have a lot of economic things that they add, like if they're running business on the land, tourism, or just because like the government doesn't want to have them be with the elections, like lose votes, if they're being seen to favor indigenous people. And so sometimes when the land claim process is happening, even though it's meant to be trying to like help the indigenous people get their land rights, when the findings made, there are really big concessions for the non-indigenous people who are already there. Like they'll say like, okay, we'll cut out this section and you can have that section still. And or if there was a lease already, they'll say it's only fair that the lease will keep going for another 10 years or something. So people feel like, they feel like that's unfair. But I guess some of that does come from Western property law systems, where in other contexts you'd think like it is, if someone's got a property interest, that should be recognized. But then that's a difficulty in translating it when, like you say, there has been a lot of historical injustice, and how to balance having like a rule of law with how to make justice for the people who've suffered a lot in the past.
Ya, sudah cukup, Pak. Thank you, Miss.
Okay, thank you for the time that has been given to me. So my name is Zaira, and now I'm in my third semester in this faculty of law. So my question is, actually in Indonesia, there was a conflict between the indigenous people in Papua with the government because of the land that they have already lived in for ages. It will Government wanted to use it for a lot of maybe industrial thing or something that will causing harm to the environment, and also the indigenous people will have no more land to live in. And for that, based on what my lecturer said in the class, that the government now is giving certificates and helping the indigenous people to have certificate for their land. But some indigenous people don't want have the certificate, but it actually there is actually talk about the legal standing for indigenous people about their land. So I wanted to ask, in Australia, is the indigenous people have their legal standing for their land? Thank you.
Thank you. Yeah, I think it's really interesting. I want to learn more about what's happening in Papua, because there does seem like there's a lot of similarities. I think when I was at UI at the conference, I met people from, it was an organization called Kaleka, and they were working with indigenous people in Papua, trying to help them map their land so that they could get certificates. But I think they were saying how sometimes, because it's so complicated, when there's so much history and knowledge and so many people, it can take like 10 years or something to get the certificate. But then if to get for like a food estate or for some land use, it only takes a few years for the government to grant that. So there's like a time issue. But I guess like I was saying, because there's a national law in Australia, it's very like if that happened to, like, when people wanted to develop, there's a process that's set out where they have to consult, even if it's in native title. The other system I was talking about, which is a weaker law, they still have to consult, or they wouldn't be able to have an agreement. Also with like social license, that's a big thing now for companies, where, like, shareholders want to see that their company is acting ethically. And so in Australia, companies have to show that they're going through the steps of consulting people, even if maybe you could be a bit cynical and say they don't really care, but they want to look like they're doing the right thing. So that's become a really strong thing now. And was that about like what would happen in Australia if Papua, the same thing? Yeah. Yeah.
consulted with the local people, the indigenous and non-indigenous, right? What the status of the land, ties to the land, and making the decision. Jadi mereka harus mengikuti proses hukum dulu, kayak kalau mau menetapkan suatu tanah itu sebagai wilayah masyarakat adat atau bukan, atau menetapkan suatu tanah ulayat itu misalnya akan dipergunakan untuk tujuan-tujuan tertentu, maka mereka akan melakukan kayak proses dengar pendapat dulu, turun ke bawah masyarakat dengar pendapatnya, kira-kira mereka setuju atau tidak ini, meskipun mungkin masyarakatnya juga kayak bukan yang terlalu antusias untuk melakukan berpartisipasi dalam kegiatan konsultasi ini. Macam kita mungkin banyak dari kita yang mungkin kayak ada terlalu clear juga kalau di sini diminta untuk hadir di rapat pendapat sama anggota DPR kita. Nah, tapi tetap dilakukan itu harus didengarkan karena itu merupakan bagian dari ketaatan dari proses. Jadi untuk mendengarkan aspirasi masyarakat di sana mengenai bagaimana pemanfaatan dari tanah ulayat ini dan bagaimana status mau ditetapkan sebagai tanah ulayat atau tidak. Ada lagi pertanyaannya? Oke, pertanyaan berikutnya lagi kita buka dua lagi pertanyaan kita.
Thank you for the opportunity. My name is Hikmah, and my question is, I've heard about Mabo versus Queensland number 2, which is often as a major case recognizing indigenous right in Australia. But from what I understand, as long as I know, please recognize me if I'm wrong. Please correct me if I'm wrong. The decision didn't fully capture the real meaning of customary law. To what extent can Mabo be seen as reducing customary law just to property rights, when in the reality, it reflects a whole way of life and shared moral system? So maybe that's it. Thank you.
Thank you. Yeah, I think in your question, you kind of summarized the problem really well. Because, yeah, it was, but I think it's the finding that happened in Mabo was like a really important finding. And there was a lot of potential at that time that about how it was then going to be applied. And so because the Native Title Act was created, like legislation from the Mabo court case. And so I guess it shows what happens when sometimes what happens in court, if it's not politically favorable, then or the government will kind of, according to its own agenda, interpret the case how it sees fit. In terms of whether it recognized customary law, I think a lot of people don't think that it did fully, because it, like you said, like it recognized that people had rights and interests on the land. But when you're talking to Indigenous people, like as their lawyer, saying like, this is what native title is, sometimes they're like, what? Like that's not a good summary of this is my land. I don't just have a right, like some rights like to go there. Like it's a very deep, like spiritual connection. And so native title can come across as being quite superficial because it doesn't give real control to people. And there's been what they introduced the law in the 90s, and it got further amended to make it that it was actually even harder to get the land, and to make it easier for mining companies and for cattle companies to stop native title from being recognized. So there's been a lot of kind of political weaponization. Yeah.
Mungkin ada lagi yang ingin bertanya? Oke, kalau misalnya tidak ada, dari mungkin tidak ada pertanyaan penutup, mungkin data ya. Maybe I will conclude the last question. In your opinion, when you see about how the development of legal pluralism in Australia, especially about the land rights, because of the position of the customary law, the Australian traditional and customary law traditional community, do you think that it will be likely that in the near future that we will see a development by which the customary law will be not just being recognized, just have its existence be recognized, but also be acknowledged formally by the constitution and the legal the law system of Australia as an independent and equal to the positive law in Australia. I think that's it.
Thank you. I would like to say that it's going in that direction, but it's unfortunately there's been some negative developments in terms of constitutional recognition in Australia in 2020. What was it? 2022? 20, when was it? Yeah. There was a referendum because right now Indigenous people aren't recognized in our constitution. There was the amendment to say that they took away this writing that they weren't citizens, but now there's no actual reference in a positive sense. And Australia was asked to vote about whether they wanted to have a voice to Parliament, which was going to be an advisory body to the Parliament where First Nations could, if there was any law that was going to affect Indigenous people, because of the history where there's been so many laws that have negatively affected Indigenous people, they were saying like, we'll make a body where people will actually have Indigenous people advising on those laws before they're passed. But unfortunately, that was voted against by the majority of the country. And yeah, I guess it's really difficult because some people for how to protect minority rights within when yeah.
Okay. Baik. Terima kasih kepada Ibu Elisabeth yang sangat mencerahkan. Mari kita berikan tepuk tangan. Nah, kita sudah memasuki kegiatan hari ini. Nah, sebelum kita menutup, saya akan kita persilakan kepada Bu Elisabeth Storor untuk melakukan penjelasan cenderamata ya. Penjelasan cenderamata yang akan dilakukan oleh Bapak Kadar dari Sekretaris Departemen Hukum Internasional.
Thank you. I feel like I've got a gift from speaking to class. I didn't even need but thank you.
Pada semua yang sudah para mahasiswa yang hadir, kami ucapkan terima kasih di thanks for thanks all of you give for heartfelt thanks also to Ms. Elisabeth for give her time to speak and enlighten us all here about what we can learn from the development of the legal pluralism and land rights in Australia. We hope that this will not be the last opportunity of her to have her here, and we hope that we can have like more critical and more extensive cooperation in the future. Okay. Dalam ucap Bismillahirrahmanirrahim. Acara ini kami tutup. Assalamualaikum warahmatullahi wabarakatuh. Ya berdiri saja deh. Nanti kita lihat bisa. Ya berdiri saja. Okay. Satu, dua, tiga. Satu, dua, kurang ganti. Iya, ganti. Ya, kita. One for you. Thank you. Ya. Ya. Ya, kita ya. Yes, yes.